So I think what we would do is take it from where we are at today. Maybe first visit with those who have already had pending applications. Was probably one of the most frustrating times, I think, in our industry on this end too, especially with the hit of COVID, closing down borders, limiting certain countries, unfortunately also South Africa, from entering the United States, consulates being limited in operating, and then USCIS almost seem like they're coming to a standstill. And if that was not enough, we had the lapse in the EB-5. So a lot of frustration and a lot of long waits that nobody would have anticipated when we got underway towards the end of 2019. But as Stuart said, very anxious and very happy to see what Congress have come up with regards to the new legislation, because there's quite a few little golden nuggets in here that I think will greatly benefit some of those who've anxiously been waiting and whose cases may not have been approved. As I've mentioned with most of you who are our firm's clients, that we do expect immigration to adjudicate these pending 5 to 6 this year within the next 60 to 90 days, because during COVID and during the pendency of the lapse in legislation, they have indicated to us that they will continue to process these pending applications, but await adjudication until obviously we get reauthorization. So we are seeing things at the consulate happening. There's a few of our folks who are lined up and teed up for the final processes and going to the US consulate in Johannesburg, which is great news. But what I think is even better news is for those who are currently in the United States. On the pending, under the previous legislation, we had to wait for the I-526 to get approved before those who are in the United States could basically move forward with regard to their green card. This new legislation has included the pending applicants and those who are newly filing to file for what is called an adjustment of status in the United States. So if you are here on an L visa, E visa, tourist visa, student visa, whatever non-immigrant visa you are on, this legislation allows you to actually file for an adjustment of status, and I'll get to that in a second, while your I-526 is pending, and for those who will be filing, to file that concurrent with the I-526. This is great news, because the adjustment of status then allows you to remain in the United States, you and your family, for as long as it takes them to adjudicate the I-526 and then ultimately the adjustment of status well. And the additional benefit that comes along with this adjustment of status is the fact that we will be filing travel and work cards along with the adjustment of status. Now that is huge, because inherently out of a green card, the two main benefits that you get out of permanent residency is the ability to work wherever you want and to travel freely without needing to go to a consulate. This work and travel card that you get while your green card I-526 and adjustment of status is pending will allow you to do so. What's even better, just as a matter of 2 days ago, USCIS has also indicated they will be adding a premium processing that one can file while your adjustment of status is pending to also expedite your work and travel card. With huge backlogs on these work and travel cards, we had to historically had people wait here until those work cards and travel cards come in to allow them to leave the country or otherwise deem their application to have been abandoned. So this is extremely helpful for future plan making, because what has happened here historically with those who have had pending applications, it is a kind of a hurry up and wait. Is it going to happen next week? Is it going to happen next month? And everybody's plans are put on hold. In the meantime, life goes on. So this has been remarkably a sigh of relief, especially for those who have pending applications. So good news all around with regards to those who have had pending applications. The National Visa Center are moving forward with regards to sending those approved notices back to the consulate. We've reached out to Johannesburg. They've already communicated that they are going to be processing those approved cases in Johannesburg here within the next 60 to 90 days and start calling people in for interviews. And then also, more importantly, for those who have more tighter timelines, on a case-by-case basis, we can talk about how to process your application while waiting in the United States, and or post-approval, come over here and change your status over here.
Yeah, Leon, I mean, this is just really exciting news all around. You know, it's it really gives investors that have been waiting for adjudication the ability to now move forward, relocate, do a status of adjustment, and not go through any additional frustrations in terms of when their case is going to be adjudicated. We at this stage don't really have an indication of processing timelines on R526s. It's just to preempt. When do you think would be the first time that we're going to see a sort of pattern emerge for those that are not anxious but are still pending and would like to wait here in South Africa for that approval to pop through?
I think once we get the first filings in, there are certain deadlines and timelines that Congress has also enacted and has formed part of this bill, when it's given some very short timelines on USCIS to actually adjudicate these cases, as opposed to just saying, well, it takes as long as it's going to take, kind of situation, which I think is also very helpful for those new prospective applicants who wants to file, knowing that there are some congressional and statutory timelines that are actually tied to these immigration benefits that's going to be filed. But otherwise, we've been told by USCIS that due to the fact that they have now had COVID and a lapse of reauthorization time to go through all of those pending applications that's been going on, that we're processing it. We are expecting here within the next 60 to 90 days to start seeing applications getting approved, and from there on, we'll be able to ascertain from when cases were filed on where their processing is with regards to those that have been backlogged and has been pending.
Great. And then Leon, just in terms of new regs and TEA, they're not current investors aren't subject to that. So their old regs are what they're going to be adjudicated on. So nothing to be concerned about on that side.
Yeah, absolutely. So not only do existing investors need to top up their investment in order to stay in the program, that's not at all the case. So you remain at the 500 that you filed at when you filed number one. And number two, there's new regulations that has been imposed upon the targeted employment areas would be grandfathered in for those who have filed under those previous TEAs. So there's also no concern with regards to the fact that your project may now all of a sudden fall outside of what the new definition of a TEA is.